My bad, folks. Looks like I was muted. I was muted. It's a rough start for the webinar. But let's go ahead and back up just a little bit. I'm George. I'm one of the founders of SoloSuit. We help people resolve debt lawsuits. And some good news here, about 70% of the time, we help people win. We get people a victory in their lawsuits. That's great. Without SoloSuit, people win less than 10% of the time in debt collection lawsuits. We consider a win to be a few things. One, if your case just gets dismissed outright. Two, you might settle your lawsuit. Or three, you might buy yourself more time in the lawsuit so that you can declare bankruptcy or something else along those lines. Debt sharks. Oh, that was my little baby there. Debt sharks exploit people, as you're finding out in this process. Let's take the real life example of Raquel. She's sued for a $1,000 debt. She wants to respond to the lawsuit. She finds out she needs to pay an attorney like $3,000 just to respond. She doesn't have money for that, so she tries doing it on her own. She finds out she has to make the answer document, which is difficult. She needs to figure out the mailing address for the court. She needs to find out and calculate the filing fee. She needs to have a printer. She needs to use snail mail probably to mail that document into the court, or she has to go down to the court in person. And then, 21-day deadline is coming up on her. So oftentimes people aren't able to respond. And in the case of Raquel, without SoloSuit, her debt might balloon into like a $3,600 judgment practically overnight. Thankfully, we help people avoid that. And you can resolve your debt lawsuit with SoloSuit. We help you answer the lawsuit. We help you compel arbitration if you're in like a credit card debt lawsuit. And we can also help you settle the debt. All right. Those are some of the basics. I think everyone's hearing me okay now, so that's great. Thanks for staying with me. Definitely going to remember to unmute next time. I think with that, feel free to start adding some questions into the chat. If you have questions, just type them into the chat on YouTube, and then we'll start responding to those. We have Hannah from Team SoloSuit on here that's going to be responding to chat. Also, I will answer questions as they come in. I'm not seeing anything in the chat yet. Okay, it looks like some things are coming in. We got Falcor. I think you watched one of our webinars before, Falcor. I think I recognize that name. He's saying, I won my suit yesterday, dismissed with prejudice. I cannot be more stoked and thankful. Falcor, excellent work, well done. Glad that we could be of assistance for you in that regard. Great. Let's see, let me just that camera a little bit. Okay. Let's see if there's any other questions coming in. While you're just writing your questions into the chat, I'm going to go ahead and get into, I'm just going to go ahead and move forward with some of these slides here as well. Okay. Falcor, again, stoked for you. Hope you do something awesome with all that money you saved by winning your lawsuit. So that's great. All right. Steps for answering a lawsuit. Number one, you got to respond to each claim in the complaint and summons. Number two, you got to assert your affirmative defenses. And number three, you got to file an answer before the deadline in court. And all of this puts you in a good position to settle. So a little bit more detail on each of these steps. When you're sued in court, in most states, you're going to receive a complaint and summons document in the mail. Alrighty? What you need to do is you need to respond to those by filing a written answer document. It's a formal legal document in court. All right? Nobody cares if you make a phone call to the law firm. Nobody cares if you send them just a regular letter. An answer document is neither of those things. An answer document isn't an answer to the collector. An answer document is a formal capital A answer document that has to be formatted properly, has to be filed in court. It's like the title of the document. It's confusing because courts are confusing. All right, but so that's the answer document that you got to do. In the answer document, you do a few things. You got to lay out the contents of the lawsuit, and then you got to respond to every allegation in the complaint. So the complaint's going to have numbered paragraphs. In the answer document, you have numbered paragraphs as well, and you respond to every statement in the complaint. All right, and then the next thing you do in the answer document is you have your affirmative defenses. Very important thing. A lot of free forms online, a lot of court forms out there. They don't actually have the affirmative defenses. We make sure that we get those in there in solo suit, in our solo suit document. And then you got to file it in the court. If you're running a little bit late, don't worry too much. Solo suit does our best to file real quick, but it can take some time. And usually courts are actually fairly lenient to accept the document that's filed a little bit late. All right, we got some other questions here stacking up, so I'm going to go ahead and get into the questions. All right. Jorge, what happens on a virtual pre-hearing credit card debt scenario? Great. All right, Jorge. A couple things to know here. Also, we share a name. Jorge, of course, is Spanish version of George, so that's great. Glad to meet you. What happens in a virtual pre-hearing credit card debt scenario? So, oftentimes how a case progresses, you get a complaint and summons. You file an answer document in court. The collector might file some additional documents that you need to respond to in court. Solo suit, unfortunately, doesn't help you out responding to those yet. Or you might just have a hearing or something scheduled in court, depending on the state. A hearing is pretty much the same idea as a trial. Most of these lawsuits don't go before a jury, they go before a judge. Sometimes you can pay extra money to go before a jury, but usually it's just going to go before a judge. So that's what a hearing is. A hearing's kind of synonymous with a trial. Oftentimes, you're talking about a pre-hearing, so that's probably like a pre-trial hearing, or like a pre-trial conference or something along those lines. Usually, what happens there is both parties have to show up. It's gonna be you, the attorney, the judge. The judge oftentimes will say something like, "Do you guys want to move forward with this lawsuit?" You might say yes. He'll say, "Have you guys tried to settle yet?" You might say no. He says, if you haven't settled, then take some time outside in like the hallway to discuss the settlement offer or something along those lines. And then if you can't settle, then it might proceed to an actual hearing, and he'll put like an actual hearing on the schedule for a month or so, or maybe a year in advance. That's the general idea. Since this is virtual, you're going to be joining on a video call system of some sort. Most courts use WebEx, which is a little bit less common video calling tool, but a lot of them use Zoom. So usually they're going to be WebEx or Zoom. Court website should hopefully have like some info about it. You'll probably want to download whatever video conference software you need beforehand and review any like rules, or basically try to find out whatever you need from your court. It just depends on each court. Probably try to contact the court, get some info from them. So there you go. That's the general idea of what happens on a virtual pre-hearing. You also mentioned that it's credit card debt. Another thing to keep in mind here is credit card debt. Credit card debt oftentimes is bought by a debt buyer. So you might have the original creditor. It might have been like Barclays Bank. Barclays Bank might have sold it to Midland Funding. Midland Funding is a debt buyer. Usually what most defendants in these cases do and how they win is they'll say, okay, the burden of proof is on the collector. And the collector can't prove that I actually owe the debt. Therefore, I should win this lawsuit because they don't have the proper documentation showing that I actually owe this debt. That's a common scenario with credit card debt. Okay. Getting into some more questions. We got lots piling up here. All right, we got Cap A. I have a pretrial coming up. What is the best way to prepare? All right. Hannah, maybe you can add our video on preparing for court into the chat. Cap A, we have like a great, that's probably like a 20-minute long video talking about all the ways to prepare for court. Main thing is get all the documentation you can on the debt. bring it with you to court. Get all your records, right? If you already paid off the debt, make sure you can like show that in your records from your like accounting or the balance of the balance and the statements on the account, etc. Bring all of that. Look nice. Show up at court. Be on time. Don't get pulled over for speeding on your way to the court. Talked to one lady who had that happen, unfortunately, a week or two ago. Definitely want to leave early, try to get to the courthouse on time. If you're in Florida, you can actually use our pilot service where you can pay for an attorney to show up in court for you. So that's great. All right, we got Jay, lived in Pennsylvania, stopped paying credit card in 2017, moved to Ohio in 2021. Credit card company knew where I was in Pennsylvania. They included it in the lawsuit, but never filed in Pennsylvania. All right, Jay. That's it's a sweet story. Not exactly sure what you're getting at here. Maybe you can add some more detail. Maybe you can ask like a question. Sounds like a situation. Maybe you got served improperly. If you got served improperly, you can bring that up as a defense in the solo suit answer document. Andrew King. I responded to the claim. How long do I wait before submitting a settlement letter? Great question, Andrea. Great question. Generally speaking, we say that people can send an offer to settle pretty much like right after filing an answer. It doesn't matter too much in what order you do or the timing. The important thing in my mind is to do both of them. You can get on our website and make an offer through Solo Settle. The offer is pretty much instantaneous. As soon as you hit the submit button on Solo Settle, we'll send an email with the offer to the collector. We've seen good results either way. Like sometimes people will send the settlement offer first, and then they'll have an answer filed a little bit later, and they can get a good settlement. Sometimes they file an answer first, and then they make an offer to settle. It doesn't seem like it matters really that much. The important thing is to do both of those things. You want to file an answer, and you want to make an offer to settle. If it were me, I'd fill out the answer document on the website, and then immediately after requesting and purchasing the answer we filed, I would then go over to Solo Settle, and I'd make an offer, and I'd click Submit. That's what I would do. You probably don't want to wait more than like 30 days to send an offer to settle. All right, we got Kanika. We have responded and denied everything. Nice work. Deny, 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 as they say. Do we then call them to settle? What if we don't have the money to settle? Okay, another good question. So SoloSuit recently released a tool called Solo Settle, which is designed to help people settle their own debts on their own. So you can use our software. It's at solosuit.com/solosettle. And you can just fill out a couple questions, then make an offer. You can like tell us how much you want to offer on the debt, and then we'll relay that to the collector for you, and hopefully get that settled. Right now, we just do lump sum payments. So if you're being sued for like $2,000, you can make a lump sum payment offer of $1,000, and hopefully the collector will accept it. Lump sum has to be paid within 90 days, so that does give you 3 months to get the money together. We don't do monthly payments or anything like that, payment plans or anything like that. You're also always welcome to settle on your own. Usually the most straightforward way to do that is to make a phone call. If you can, I would do it by email, because that gives you a little bit more, kind of evens the playing field a little bit, rather than negotiating with a professional negotiator on the phone. Then you're just kind of going asynchronously by email, which is a little bit easier to do. And if you are settling directly with the collector, it's very likely that they'll offer you a payment plan, so you can like make monthly payments. That's a pretty common thing to do. We just don't support that on Solo Settle yet. So if you need monthly payments, you're welcome to just try to settle with them directly. Rochelle, I used SoloSuit to answer questions sent by the plaintiff. So to answer the complaint summons. Now they've sent me a plaintiff's discovery document after I responded to my discovery plan. What do I need to act on this? So Michelle, sounds like you received the complaint and summons, or maybe a petition and citation if you're in like Texas or something, and then you filed the answer, and then they sent you a discovery document, and you're wondering how to respond to the discovery. I'm not exactly sure what a discovery plan is personally. Not sure if that's like a universal term. I haven't heard it before. You're asking particularly, do I need to act on this? Probably. Usually how a court case goes is one party files a document, and then the other party files a document. And then if it's a big case, there's a hearing to talk about the two documents that each party filed. If one party doesn't file a document in response to the other party's documents, then the party that filed first will get whatever they wanted, whatever they asked for. Right? So that means that if the plaintiff filed like a motion for discovery and then you don't respond, like if they filed a request for admissions and then you don't respond to that, then probably all of the statements in the request for admissions will be considered admitted, and you really don't want that. So you want to make sure you respond. Fortunately, again, SoloSuit doesn't have additional documents for that. But you can do your best guess. You can take a look at our blog. We have a lot of good resources on there, and hopefully that will help you out. All right, Cap A. Again, I've been with a debt consolidation company, and one bank settled 2 of their cards, but want to sue on a 3rd. All right, cool. Hey, that's good to know, Cap A. Good to know you're with a debt consolidation company. Sounds like the consolidation company has like settled 2 accounts with one bank, but that same bank has a 3rd account that they're planning on suing for. That's a really common situation for our customers. A lot of our customers come to us from debt consolidation companies. So basically, if you're in a debt consolidation company and one of your accounts, you get a lawsuit on it, you can just use SoloSuit to respond. You just use their answer document, respond. That gives the debt consolidation company extra time to try to continue settling the lawsuit. Unfortunately, a lot of debt consolidation companies don't have a law firm backing them up. So if you get sued, they can't do anything for you. A lot of them actually refer people to us. Some of the bigger ones like Freedom, Debt Relief, have their own in-house law firm or something along those lines that helps and protects you against these things. All right. We got another comment here from Jay. Pennsylvania has a shorter statute of limitations than Ohio. 5 years versus 6. Would this be venue shopping? Interesting. That's an interesting point here. So you're saying you want to like move it from one state to the other state? You want to move the lawsuit? You want to make a request for a venue change? That's certainly an appropriate thing to do. I mean, oftentimes, like real lawyers and in big cases will be moving lawsuits around. That's oftentimes the first issue that is disputed is like the venue. They'll either, if it's in state court, they'll try to move it to federal court. If it's in one state, then they'll try to move it to like another state, etc. And that can go on for quite a long time. I think you do have to file like a request for change of venue of some sort. And the venue, it sounds like you want to change the venue because the statute of limitations is more favorable in a different venue. So that's not exactly the right way to think about it. In a case, the venue has to be determined as well as the applicable law. So in theory, you could like try a case in Illinois and apply Pennsylvania law. A little bit less common, but if the venue is determined to be Pennsylvania, it doesn't necessarily mean that the statute of limitations in Pennsylvania law is the one that applies. It's probably going to be the one that applies is where you took out the debt or like had debt most of the time. I'm not exactly sure about how that's applied, but that would be the case. Like if you got a credit card in Pennsylvania, it's probably the statute of limitations in Pennsylvania that's going to apply. Again, that's definitely something like you probably need to talk to an attorney to really figure out. My camera keeps on moving over. That's a little bit of a nuanced idea, but certainly you can try changing the venue. We got another J. Just want to say thank you for your service. It's wonderful. My wife is in the middle of being sued by a couple credit card companies to avoid default judgments. We used your service to file responses. Great. Jay, happy to hear it. Thanks so much for the kind words. The whole team's happy to hear it. Definitely hope you win your case. If you haven't made an offer to settle yet and you think you might want to, you can go over to Solo Settle, make an offer. If you also think you should just win the lawsuits, you can tough it out and hope for a W. All right. Let's see. Angela, I have one account in particular. It was open in Texas and charged off in 2019. I relocated to Florida where the SOL is 5 years. A lawsuit was filed against me in Florida. Is this legal? Okay, let's jump into that here a little bit. I have one account. There's a Texas account charged off in 2019. And she moved to Florida, and she got a statute of limitations in Florida is 5 years. Basically, you're just saying that you had an account in Texas, and then you moved in Florida, and you're sued in Florida. Yeah, I mean, everything about this seems legal initially to me. Again, I'm not an attorney here. But yeah, I'm not sure exactly what's not adding up. I guess what oftentimes happens is someone will have like a credit card in one state, they move, they get sued in the state that they moved to. Sometimes they get sued in the old state. Both can be a painful situation. Honestly, like determining which jurisdiction the lawsuit should be in, which venue it should be in, can be a pretty tricky matter. I think most people would prefer to be sued in the state that they actually live in, because otherwise they might have to travel to the other state, which can be pretty painful. The statute of limitations may have expired. It just depends. The statute of limitations starts ticking from the time that you last made a payment on the account. So in this case, if you made a payment in 2019, that's only been like 4 years maybe because it's 2023. But if you made a payment last in 2014, then yeah, statute of limitations probably did expire. However, the important thing to note is that even if the statute of limitations has expired, it's up to you to bring that up and point that out in your answer document. Just because the statute of limitations has expired doesn't mean that they can't sue you for it. It means that you have to bring it up as a defense in the lawsuit. So if you don't respond to a lawsuit and the statute of limitations has expired, then nobody cares. Like, the judge isn't the referee. He's not going to look into it for you. You have to file an answer to notify the court that statute of limitations has expired. All right. And statute of limitations, if it has expired, is a bulletproof defense. Very good defense. So definitely want to bring it up if it has expired. All right, Stephen, what do you do if the company stopped collecting money from account, then writes it off, and you get a summons? Yeah, it's a pretty common situation. I'm not sure exactly what you mean by stop collecting money from an account. If that means like you had an auto pay set up and then they just stopped the auto pay, then they sued you because you weren't paying, and then that's certainly a fact that can be brought up in the lawsuit in a hearing or in discovery, not in the answer document. But generally, when you get a summons, you also get a complaint, and you just want to respond by filing an answer document in court. That's the basics. You can use Solo Suit to file an answer document. You want to respond by the deadline. You want to get that done. And Angela, the statute of limitations in Texas is 4 years. By the way, we have a statute of limitations calculator on solosuit.com. I think if you search like statute of limitations calculator in SoloSuit, the blog post there will come up with the calculator. That has all the latest statute of limitations laws in it. So just, you might want to double check yourself. I don't remember the Texas SOL offhand. But yeah, if the SOL, if the statute of limitations expired in one jurisdiction and you're being sued in a different jurisdiction where it hasn't expired, it's an interesting question, right? I think normally a lawyer would file an answer for you, and in that answer they'll make the affirmative defense saying that the statute of limitations has expired. And then in the hearing, you can kind of work that out and figure it out whether or not it actually has expired or not, but you want to bring it up in the answer document. Because if you don't bring it up in the answer document, you can't bring it up later. J, not working to do some form of a reduced settlement before the trial date or take it to trial, but really appreciate your easy use service. That sounds good. So we got some answers here from Hannah. We got C, question from C. Is it too late to file to compel arbitration if the opposing party has filed a motion for summary judgment in Florida? Solo suit responded for me to the original summons. Just a little semantics there. Yeah, you use solo suit to file an answer in Florida. Okay, so it sounds like a motion for summary judgment was filed in your case in Florida. So that's not a good thing, right? So if the plaintiff, if the collector files for motion for summary judgment, what they're saying is that they are asking the judge to give them a summary judgment against you, meaning that you would lose the case. They're asking the judge to say the plaintiff wins automatically. The plaintiff wins before there's even a case because the defendant doesn't have a case. So that's not good. So what you want to do, this happens a bit. What you want to do, though, is respond by filing a counter motion or a motion opposed to the motion for summary judgment, saying that you're asking the judge to rule in your favor because you do have a case. And pretty much all these debt collection cases, the judge should rule in the favor of the non-moving party of the defendant in this situation, requesting there is no summary judgment. Because in my mind, I mean, if you're contesting the case, you're saying that the plaintiff can't prove it, then the plaintiff needs to prove it, and there shouldn't be a summary judgment. So you definitely want to respond to the summary judgment. You might want to file also a memorandum in support of the motion opposed to the motion for summary judgment. Again, not documents that we do, but you can probably find out some good information online about that. And you can get it filed in court. It's not too late to file a motion to compel arbitration. You can file a motion to compel arbitration at pretty much any time before judgment. It could be a good move in your situation if your credit agreement has a arbitration clause in it. If it's a credit card, you can look it up on the Consumer Financial Protection Bureau. They have a database of credit card agreements, and you can check that out there. All right, let's see. What else have we got here? All right, that is about the half hour, so I'm just gonna have to kind of cruise through some more of these questions. Kind of lost my spot here. Let's see. Let's see here. Okay, we got Rochelle. How long do I have to respond to plaintiff's discovery document? The document does not indicate. Good question. You can try calling your court, ask the clerk how long you have to respond. You can try looking up you can try looking up your state's rules of civil procedure. Ultimately, that's where the answer is. So you search like rules of civil procedure for your state, and then look up discovery or like timelines. Usually, it's going to be pretty similar to the time frame to answer to file an answer document. So it might be like 30 days or 20 days. Generally, you want to respond as quickly as you can. Andrea, if I denied the amount of the medical bills, do I wait until they send me the bills breakdown before I submit the settlement letter? Yeah, it's kind of up to you. Certainly a fine move to wait for them to prove it and to show you actually how much you owe. Also, if you just want to get it figured out earlier, you can make a settlement offer now using solo suit or solo settle. Jay says they knew where I lived. They chose not to sue me until I moved. Yeah, it sounds like the collector is trying to do a sewer service where they serve you at your old address, knowing that you won't be able to get the lawsuit from there. It's a pretty messed up thing, but the best thing to do is to file an answer and then allege improper service. Let's see. Just trying to move along to the next guy here. Bergs, if you send the settle letter, aren't you basically saying you owe the debt? Not exactly. Some states have nuanced laws, but most of the time, if you offer to settle, it's not going to actually be used against you in court if it continues going to court. People can settle for a wide variety of reasons. Settlement isn't necessarily an indicator of of guilt or liability. You can settle for whatever reason you want. So someone might settle because they have a lot of money and they're being sued and they don't want to deal with the lawsuits, so they might just settle even though they aren't liable at all. Jules, what if I don't have enough to pay back the unsecured loans of $15K? Yeah, that's a real situation. You might want to get onto a payment plan with the collector. You might want to try to settle. Most of the cases on solo settle so far have settled for 50 to 60% of the total amount of the debt. So in 15K, you might be able to get down to 8K, which would be a great deal. And that's the situation there. All right. Skipping ahead here. Kanika, once we have settled, can we then add the debt to a debt relief program? Interesting. If you're already enrolled in a debt relief program, then they might be able to take care of that for you. I guess I'm not sure why you would add it into a debt relief program. I think you probably just want to make payments directly to the collector at that point. And then you might want to refinance the amount of the settlement maybe. Most of the time the collectors are going to require you to pay it pretty quickly. Usually they try to get you to pay it within 30 days. We negotiate for 90 days on settlements. Those are some thoughts on that. All right, moving ahead for time's sake here. Let's see. Linda, if it was a car loan and the car was voluntarily given back and was sold, the company is considering that a payment on the account for me. Is that correct? Yeah, so if you had an auto loan and the car was returned and then sold, in theory that revenue from selling the car should be applied to paying off the loan. These auto loans can get pretty weird though sometimes. I've certainly seen positions where a car is sold or repossessed but not applied to the loan. You're still probably going to be on the hook for the interest in the loan and the remainder of the loan after the sale of the car. So that's kind of a situation on the auto loan. Audrey, how do you help your customers avoid making admissions in their answer/response document? Great question, Audrey. When people are concerned about that, they usually end up buying the premium package, right? So the premium package has an attorney review. The attorney will review the document, and then basically will determine whether or not something should be admitted or denied in an answer document there. All right, and I think that's we got Rochelle here saying thank you for all the advice and guidance. Thanks for coming, Rochelle. All right, I think that's pretty much all we have time for today. We do these webinars pretty much weekly, so we'll probably be back next week, Wednesday, same time. If there's another time that you'd rather do, just let us know. Send us an email. Thanks for coming. Hope all of you guys win. At Solo Suit, we are rooting for you guys. We're rooting for all of you. You can know that you always have someone in your corner with Solo Suit. All right, good chatting with you.